Islam, Islam, Islamism. I am Sister Tahita S. Najiola L. of CalifaMedia.com and numerous other projects. This presentation was created in response to a pattern many of us recognize too well, wherein our creativity generates value, yet others secure the paperwork and control the benefit. The intent here is to demystify federal trademarking and show that it is a lawful, accessible tool for protecting what we create. My objective is not just to explain the process, but to shift how we think about ownership, structure, and timing. By the end, this presentation aims to equip you to move from creation to protection and from participation to control. Islam, let's get started. This opening moment sets the frame for everything that follows. This presentation is not about hype, trends, or fear. It's about ownership. When we talk about trademarking, we are talking about who controls names, symbols, reputations, and economic value attached to them. Too often, our people create, popularize, and legitimize ideas only to watch someone else secure the paperwork and collect the benefits. I want to be clear from the outset, this is not theoretical. I have personally filed 3 federal trademark applications. 2 are registered. Again, that's federal. I've done state as well. One of the federal is still pending, but I do have 2 that are registered. What I'm sharing with you today is not secondhand information or legal speculation, but lived experience navigating the federal system successfully. Trademarking is not just for multinational corporations. It is a lawful, accessible tool that allows you to convert creativity into protected property. When you own your own mark, you are no longer asking for recognition. You are asserting control. That control becomes economic self-defense because it forces the world to either innovate independently or compensate you for use of what you created. This presentation will walk you through the mindset, the structure, and the strategy behind federal trademarking so that by the end, you will understand not only how to file, but why filing is a necessary step in protecting your legacy. At this stage, the conversation has to shift from visibility to control. Many people assume that recognition, popularity, or public support offer some form of protection. They do not. None of those things create enforceable rights. Ownership does, and ownership is established through documentation, not consensus. When we talk about moving beyond ideas, we are really talking about moving beyond informal creation. Ideas are abundant. What is scarce is legally recognized control over the identifiers attached to those ideas, such as names, phrases, symbols, and reputations. A federal trademark is the tool that converts something recognizable into something defensible. The stakes are often misunderstood. Trademarking is not about ambition or ego. It is about risk management. If you do not own the legal rights to your brand identifiers, you are operating as a tenant rather than an owner. Your continued use of your own name or concept then depends on no one else filing first. Once someone does, your longevity depends on their tolerance, not your contribution. This is why trademarking functions as economic self-defense. It establishes priority, creates public notice, and gives you standing if your work is copied or displaced. Without it, even successful creators remain vulnerable to erasure. The central point here is straightforward. Protection is not something you argue for after the fact. It is something you establish in advance through structure and documentation. Everything else flows from that foundation. Here we have a real-world example that illustrates how value can shift hands without any theft in the traditional sense. What happened in the so-called Mr. Tenderism case was not the loss of an idea, but the loss of ownership. The phrase, the energy, and the cultural momentum were created and popularized by an individual. However, the legal ownership of the mark ultimately belonged to an entity that completed the federal filing process. This distinction is critical. Creation and ownership are not the same thing. Yeah, they should be, but they are not the same thing. The law does not reward those who thought of something first or who made it popular. It recognizes who secured the rights properly. In this case, the creator became the face associated with the phrase, while the entity that filed the trademark became the legal owner of the economic engine behind it. What's important here is not assigning blame, but extracting the lesson. Hesitation creates opportunity for others. When the mark is left unfiled, it remains available to anyone who understands the system and acts decisively. Once filed and approved, that ownership is enforceable regardless of who introduced the concept to the public. This is why timing matters. Trademark law operates on priority and proof, not intent or fairness. If you delay filing because your project feels unfinished, informal, or still growing, you are leaving the door open for displacement. The key takeaway is not fear, but awareness. Value transfer happens at the point of paperwork, not popularity. Filing early is not aggression, it's preservation. At this point, we step back from a single incident and begin to recognize a repeating pattern across industries and generations. What we are looking at is not coincidence. It is not limited to food, dance, music, or branding. It is a structural expectation that our people will generate value without securing ownership, leaving the door open for others to formalize, monetize, and control what we originated. Across time, we see the same sequence. Creativity emerges from our communities. It gains traction because it resonates. Then once its commercial potential is obvious, someone else steps in with contracts, corporations, and filings. The value does not disappear. It simply transfers. Culture becomes commerce the moment paperwork enters the picture. I have heard members of other nationalities refer to our people as liquid money. What they are acknowledging, even if disrespectfully, is our unmatched capacity to generate ideas, aesthetics, language, and movements that convert directly into profit. What they also assume is that we will not protect those interests. That assumption is what allows them to swoop in and collect our gold. This is not about talent. It's about the expectation that we will remain informal, grateful for visibility, and unfamiliar with legal tools. Trademarking interrupts that pattern. It signals that creation alone is no longer enough. Ownership must follow. The analytical takeaway here is simple. Extraction persists where protection is absent. When we claim our creations formally and consistently, the pattern breaks. Recognition becomes compensation, and contribution becomes control. This moment marks a transition point in the presentation. Up till now, we have been identifying the problem and the pattern. Now we shift into solution and capacity building. The goal here is to remove intimidation from the trademark process and replace it with clarity. One of the most persistent barriers our people face is the belief that federal systems are inaccessible without attorneys, large budgets, or corporate backing. That belief is not accidental. Complexity discourages participation. Demystification, therefore, is not just educational, it is corrective. The first objective is to break the process down into understandable parts. Federal trademarking follows a defined sequence. Once you understand the purpose of each step, the system becomes navigable rather than overwhelming. You are no longer reacting emotionally to unfamiliar language, you are making informed decisions. The second objective is accessibility. Trademarking is not reserved for major corporations. Individuals and small entities file successfully every day. The difference is not status, it is preparation. When you know what the government is actually asking for, you can meet the standard without outsourcing your authority. The third objective is action. Waiting for perfection is one of the most common mistakes. Filing is not a reward for success. It is a tool that protects growth. Delaying action increases vulnerability. Finally, this requires a mindset shift. We move from reacting to theft towards asserting ownership. Trademarking is not about complaining after the loss. It is about securing control in advance. That shift is where real protection begins. At this point, it becomes important to draw a clear line between what people assume a trademark does and what it actually accomplishes under federal law. Much of the confusion around trademarking comes from inflated expectations on one end and underestimation on the other. A federal trademark does one primary thing. It establishes your legal claim to a specific identifier in connection with defined goods or services. That identifier may be a name, phrase, logo, or slogan. Once registered, it gives you nationwide priority, even if your business activity began locally. This means your claim is no longer limited to your immediate area or audience. What a trademark does not do is protect ideas, concepts, or cultural practices in the abstract. It does not prevent others from creating similar products or services. It does not grant ownership over language broadly. Its power is precise and tied directly to use in commerce within specific classifications. This precision is a strength, not a weakness. By clearly defining what you own and how it's used, the law provides enforceable boundaries. Those boundaries allow you to stop confusingly similar uses, license your mark to others, or transfer ownership intentionally as your structure evolves. Understanding this distinction prevents two common mistakes: assuming a trademark gives you control over everything, or assuming it gives you nothing of value. In reality, it gives you exactly what the system recognizes and enforces. When used strategically, that recognition becomes leverage, credibility, and long-term protection built on clarity rather than assumption. All right, before we really get into it, let's break down a few terms so you'll feel confident as we go along. First, a trademark is any word, name, or symbol that identifies the source of goods, okay, like physical goods. A service mark is basically the same thing, but for services instead of physical products. Now, a word mark is when you protect just the name or words, no matter how they look. A design mark covers a specific logo or stylized design. All right? This is where many first-time filers make their most costly mistakes, not because the concepts are difficult, but because timing is misunderstood. Federal trademark law recognizes two legitimate pathways to ownership, and choosing correctly depends on what you are actually doing, not what you hope to do. Use in commerce applies when you are already selling or providing goods or services across state lines. This may include physical products shipped to other states, digital products sold nationally, or services offered beyond your home state. In this situation, you must show that the mark is actively being used in connection with what you offer. Proof matters. Screenshots, listings, packaging, or service pages become evidence. Intent to use applies when a mark is planned but not yet active. This is common when someone is building a brand, preparing a launch, or organizing an entity. Filing under intent to use allows you to reserve the mark while you prepare and establish priority before activity begins. Here's the key cost consideration. Intent to use costs the same to file as use in commerce, but it does not end there. After approval of intent to use, you must submit additional paperwork later to prove actual use, and that filing includes an additional government fee. In most cases, intent to use costs more overall. This does not make intent to use a mistake. It is appropriate when timing truly requires it. Problems arise when people choose it assuming it is cheaper or easier. The practical takeaway is simple. File under use in commerce when you legitimately qualify to save time and money. Use intent to use when you need to secure priority before launch, understanding it is a two-stage commitment aligned with preparation, not convenience. At this stage, filing becomes less about eligibility and more about strategy. Trademark classes are one of the most misunderstood aspects of the process, yet they directly affect both cost and protection. Each class represents a category of goods or services that your mark will cover. The government does not assume expansion. You must claim what you want protected. From a cost perspective, every class carries a separate filing fee. Filing for everything at once may feel thorough, but it can be wasteful if your offerings are not clearly connected. Overfiling increases expense and scrutiny without increasing enforceable value. From a planning perspective, underfiling can be just as limiting. If your mark is protected only for books, but you later expand into education, apparel, or digital services, your original registration may not cover those activities. At that point, someone else could legally claim the same or a confusingly similar mark in a different class. The practical approach is balance. Start with what you are actively offering or reasonably prepared to offer. If expansion is planned, choose classes that logically align with that growth rather than speculative ones. For example, a creator selling physical books may also reasonably include educational services, but not unrelated merchandise. Class selection is not about predicting every future possibility. It is about aligning protection with reality and intention. When done correctly, it controls costs now while preserving flexibility later, allowing your trademark to grow alongside your work rather than restricting it. Here, the emphasis moves from what you claim to be doing to what you can actually demonstrate. In the trademark process, this evidence is called a specimen. A specimen is proof that your mark is being used in real commerce, not just planned, imagined, or designed. Many applications run into trouble here because people confuse marketing materials with proof of use. A logo by itself is not a specimen. A mock-up is not a specimen. A name on a business card or a draft website that does not offer anything for sale will usually fall short. The USPTO, or the U.S. Patent and Trademark Office, is looking for clear evidence that the public encounters your mark in connection with actual goods or services. For physical products, acceptable specimens often include product packaging, labels, tags, or online listings where the item can be purchased. For digital products, it may be a sales page showing the mark alongside a download or purchase option. For services, it is typically a website or advertisement where the mark appears together with a clear description of the service being offered. The underlying principle is straightforward. The government is not interested in your intent at this point. It wants to see use. That use must be ordinary, public-facing, and tied directly to commerce. Understanding specimens prevents unnecessary refusals and delays. When you prepare your evidence carefully, you are not just complying with a requirement, you are demonstrating that your mark already functions in the marketplace. That demonstration strengthens your application and reinforces the broader theme of this presentation. Protection follows structure, clarity, and disciplined execution. One of the most consequential decisions in the trademark process has less to do with the mark itself and more to do with who holds it. Whether you file as an individual or through an entity determines how that trademark functions over time, especially as your work grows, shifts, or outlives you. Filing as an individual is often the simplest starting point. It can make sense when you are the sole creator, operating informally, or testing an idea before building infrastructure. The trademark belongs to you personally, and you control its use directly. The limitation appears later. If the business expands, is sold, inherited, or reorganized, the trademark must be formally transferred. Without planning, that transition can become messy or contested. Filing through an entity introduces structure. In this arrangement, the trademark becomes an asset of the organization rather than the extension of one person. That distinction matters for continuity, licensing, and longevity. The mark can survive leadership changes, be licensed intentionally, or be protected from personal liabilities when properly structured. This decision is not about right versus wrong. It is about alignment. Individual ownership prioritizes flexibility and speed. Entity ownership prioritizes continuity and scalability. Problems arise when people file individually while operating as organizations, or form entities without transferring ownership properly. The broader lesson is strategic awareness. Trademarks do not exist in isolation. They sit inside legal structures. Understanding where your mark should live is part of protecting not just a name, but the future value attached to it. Sound trademark strategy is less about avoiding mistakes and more about adopting habits that protect value over time. Best practices exist because trademarks are not static filings. They are living assets that interact with growth, structure, and succession. One best practice is clarity before filing. That means being clear about what you are offering, how it is delivered, and who should own the mark. When those questions are answered in advance, filings tend to be cleaner, stronger, and easier to maintain. Ambiguity at the beginning often leads to corrections later, which cost time and money. Another best practice is consistency in use. The way your mark appears publicly should align with how it is filed. Small changes in wording, spacing, or presentation can weaken enforcement if they create confusion about what is actually protected. Consistency reinforces recognition and strengthens your position if challenges arise. Documentation is also critical. Keep records of first use, sales activity, licensing arrangements, and renewals. These records are not just administrative, they are evidence. When questions arise, documentation turns assumptions into proof. Finally, best practices means thinking beyond the present moment. Trademarks should be filed with continuity in mind. Who controls the mark if leadership changes? How is it licensed or assigned? Planning for those questions early prevents disputes later. The core principle is intentionality. When trademarks are treated as strategic assets rather than afterthoughts, they retain value, command respect, and remain enforceable as your work evolves. By the time someone reaches this point in the process, a pattern usually emerges. Trademarking has clarified not only what you are protecting, but whether your current setup can actually hold that protection. Many people discover that their creative or community work has outgrown the informal arrangements they started with. A trademark is an asset. Assets need a place to live. When a mark is held personally while the work functions organizationally, tensions appear. Questions arise about ownership, control, income, liability, and succession. These questions are not caused by trademarking, they are revealed by it. Best practice is to respond to that signal rather than ignore it. If your mark is tied to education, publishing, religious, or cultural work, it may require an entity capable of holding assets, entering agreements, and operating beyond one individual. Structure is not about bureaucracy, it is about durability. This is where incorporation becomes relevant, not as a default, but as a solution. The appropriate structure depends on purpose, activity, and values. Some work fits within traditional business entities. Other work aligns better with religious or nonprofit frameworks. The key is alignment. Trademarking often becomes the moment when people realize they are building something larger than themselves. When that happens, structure stops being optional. It becomes the means by which value is preserved, responsibilities are clarified, and the work can continue lawfully and intentionally over time. Once the relationship between trademarking and structure becomes clear, The next question is practical. How do you put the right framework in place without guessing your way through it? Insight alone does not protect assets. Implementation does. Many people reach this stage realizing they need more than a single filing. They need a repeatable process for organizing their work lawfully, aligning ownership with purpose, and documenting decisions in a way that holds up over time. This is especially true when the work involves education, publishing, or religious and cultural activity, where traditional business templates often fall short. Best practice is to rely on systems that are already structured for compliance rather than improvising piece by piece. A well-designed incorporation pathway clarifies who owns what, how decisions are made, how assets are held, and how the work continues beyond one individual. It also prevents the common mistake of fixing problems only after value has already been created. This is where guided resources become useful. Tools that walk through incorporation step by step, explain why each decision matters, and connect structure to strategy help close the gap between knowing and doing. When paired with clear education on how corporations function, those tools turn abstract concepts into actionable steps. The goal here is not speed for its own sake. It is alignment. When trademarks, entities, and purpose are designed to work together, protection becomes sustainable rather than reactive. This is how ownership is preserved intentionally rather than defended after the fact. By now, you should be clear on several things. Trademarking is not reserved for corporations or attorneys. It is a process governed by logic, sequence, and evidence. When you understand how use, timing, classes, specimens, and ownership fit together, the application stops feeling intimidating and starts feeling procedural. This preparation matters because federal systems do not reward emotion or intent. They respond to alignment. When your facts match your filing basis, when your specimens reflect real use, and when ownership aligns with structure, the system works as designed. Problems tend to arise when people skip the thinking phase and jump straight into forms. Rather than rushing straight into the mechanics, I want to give you space to prepare. What you have been exposed to here is not just information, but a way of thinking about ownership, structure, and protection. That kind of understanding benefits from reflection. I encourage you to review your own work with these principles in mind. Think about what you are offering. How is it being used in commerce? And who should properly own the mark? Begin identifying materials you would need to support a filing, such as examples of use, product or service pages, dates of first use, and how your name or mark appears publicly. This is not busy work, it is preparation. When we reconvene a week after posting of this video, I will walk you through one of my recent federal trademark filings step by step. You will see how the decisions we discussed translate into real choices inside the USPTO system. The walkthrough will make far more sense if you arrive already thinking like a filer, not a spectator. Use this time intentionally. Trademarking is not something to rush through at the last minute. It rewards clarity, organization, and foresight. Giving yourself time to gather your materials and think critically about your structure puts you in a position to follow the walkthrough with confidence and purpose rather than confusion. That preparation is what turns observation into readiness. Thank you for joining. Gratitude for your time and your attention. And I'll see you on part 2 of Trademarking for Moors. Islam, peace and love. Bye-bye, y'all.